under the discrimination category, there were a couple of changes. The definition of protected classes under the FEHA now includes members of the military and veterans. So, for example, if you now are going to take an action against an employee, an adverse action, and you say, oh, you call your lawyer and they say, well, they in a protected class. You don't, it includes now, in addition to race, gender, over 40, all those, it now includes military members and veterans. So you need to be aware of that. SB 292 changed the definition of sexual harassment to basically state that sexually harassing conduct need not be motivated by sexual desire. And the genesis of this statute was a decision that came down a couple of years ago from a California Court of Appeal, where you had a supervisor who basically had been harassing it was a male supervisor harassing a male subordinate, basically with vulgar comments, implying that he was gay, making all these comments. The person sued for sexual harassment, the employee did, and the Court of Appeals said, well, that's not really sexual harassment because there's no evidence that the supervisor was gay or was motivated by any sexual desire. So the legislature said, well, that it's still sexual harassment because it was based upon a perception of the person's sex. And so consequently, they changed the statute, amended the statute to include in the definition that it need not be motivated by sexual desire. So basically any hostile conduct that's based on someone's sex now is going to be considered sexual harassment. Harris versus the City of Santa Monica. This is a California Supreme Court decision last year which basically addressed the standard for proving discrimination. And what it did is that the plaintiff, under the Harris case, the plaintiff must prove that the act that was taken, the discriminatory act, was a substantial motivating factor in whatever employment action was taken. So they have to prove that their gender or their race or whatever it might be was a substantial motivating factor in the action, whether it was a firing or a disciplining or something like that. If the defendant, the employer, can show a legitimate reason for the action that they took, then that would tend to disprove the fact that it was a substantial motivating factor. Bland versus Roberts. This is an interesting case. It came out of the state of Virginia, actually. And there was a deputy sheriff whose boss, the sheriff, elected sheriff, was engaged in a really nasty race re-election campaign for sheriff. This deputy sheriff basically went onto his boss's opponent's Facebook page and liked it. Got fired. And he said, well, you can't do that to me because that's protected conduct. And actually the Bland case said, yes, it was protected conduct. What's interesting about it and what's important for you is the information that you learn from social media and how you need to be careful about that. Because in this case, the sheriff might have had a legitimate reason for firing this deputy, but because he knew the deputy had liked his opponent's Facebook page, that was a wrong reason. If he hadn't known that and he had other legitimate reasons for firing the guy, he probably could have gotten away with it. So when you or your supervisors learn of things from social media, that can be dangerous, and you need to be very careful about what you do with that information. And to some extent, you need to try and restrict that information. Now, people like to go on the internet and find out all sorts of things about people, but it's in the employment context, it can be very dangerous.